So this panel is about making attempts to limit the harms of family policing and what's happened, what's worked, and what have our challenges been. I'm going to introduce our moderator, the wonderful Shanta Trivedi. Shanta is an assistant professor of law and faculty director of the Sarah Neal Meyerhoff Center for Families, Children, and the Courts at the University of Baltimore School of Law. It's a very long title. Congratulations. So long. She teaches family law and child welfare law. She previously served as a clinical teaching fellow at the University of Baltimore School of Law's Bronfine Family Law Clinic and the Domestic Violence Clinic at Georgetown University Law Center. Prior to joining academia, Trivedi was a staff attorney at Brooklyn Defenders Services Family Defense Practice, representing parents embroiled in the child welfare system. Through this work, she tackled the myriad of challenges facing low-income, minority, and otherwise disadvantaged families and developed her scholarly interest in family separation. Shanta is a widely published legal scholar. Please read her work. It's great and long. She's a policy advocate in popular media with a focus on promoting policies and primary prevention approaches to reduce family separation by the child welfare and other legal systems. So welcome to this panel.
Thank you, Kristen. It's always weird to hear your bio read out loud, but thanks. I just wanted to acknowledge, it's that time of the day. I know we have the after lunch slump, and everyone that I've asked how you're doing today has said, girl, I am so tired. And I just wanted to acknowledge that we are all so tired. And the reason that you are so tired is because you are out there doing this work, and it is exhausting. But part of the reason you're exhausted is also because people are listening. And that means there's more opportunities to speak and more opportunities to organize. And I just wanted to acknowledge that we are tired, but it is good. And to also say that I've attended this twice online, and it is so nice to be here in person and to be with you and to feel your energy and to be inspired by all of you in this community. And I just wanted to say thank you for inspiring me. And for being here with us to continue this work. Wasn't planning to do that whole spiel, but I felt, we're gonna get this energy going. So I wanted to say thank you for joining us in this conversation. And, there's no doubt, right? This movement is gaining some momentum in a lot of realms, right? And we're seeing that really acutely in terms of legislative and policy change. And the panel description says that we will discuss strategies we've used to achieve policy wins that move us towards a more equitable and just society without family policing. And I will say, when we were planning, we were a little hesitant to talk about wins, right? Because a lot of the policy and legislative changes don't really effectuate the kind of broad change that we are seeking and that we believe is necessary. And many of them are tweaks. Many of them are sort of quasi-reformist reforms. Some are true non-reformist reforms that either shrink the system or reduce harm. But we are making progress. And in Maryland, where I live, the law was recently changed to clarify that marijuana use without actual harm is not neglect under the law, and that is a tiny change. And honestly, it wasn't even a change as is what the law says, but people couldn't understand it. So we clarified, and that was a really tiny change, but it's one that we hope will reduce some harm of the system. In Texas, families are gonna have Miranda-like warnings to understand their rights when CPS comes to the door. And there are a lot of other changes happening around the country, spurred by the work of the people in this room and online. And we are just so grateful for all of your work and your effort and for your resistance. So just for a little framing, in 2019, I published an article called The Harm of Child Removal. And in that article, one of the things that I proposed was that the law should, seemed logical, right, consider the harm of removing a child from their family in addition to any other harms. And At the time that I published that article, there were only two jurisdictions in the country that took harm of removal into account. And since then, thanks to people like you, at least 4 more jurisdictions have passed legislation that requires judges to consider the harm of removal in removal decisions. California's was literally signed by the governor last week. And the legislation in each state is very, very different. And as such, we thought it would be a useful lens for us to sort of think about legislative and policy change. Because the approaches to how these laws were passed were really different in each state. What the text of the law says is really different in each state, and the impact has also been really different in each state. 2 of these states are Iowa and Washington, where my colleagues Carrington, Buze, and Tara Urs are from. And in a second, I'll let them introduce themselves. But we do really want to have an honest conversation, not just about the promise of policy and legislative reform, but also its limitations. And also we want to hear about the work that you've all been doing. We want this to be an open conversation, and we'll leave time for questions at the end. So, Carrington, why don't you introduce yourself?
Hi, I'm Carrington Buze. I'm not from Iowa. I live in Iowa. I am from Phoenix, Arizona, and I'm the staff attorney for Iowa's Children's Justice, which is the court improvement project housed inside of the judicial branch. And on another note, I was a Title IV stipend student, and about a year in, I was like, what am I doing? But I didn't have about $20,000 to give the state back for breach of contract. So very much so, the Title IV stipend program it's a thing.
Tara?
Hi, I'm Tara Urs. I work at the King County Department of Public Defense, which is in Seattle. I'm a member of the Keeping Families Together Coalition.
All right, so I want to start by just asking you each to describe some of the legislative changes that have occurred in your state in the area of family policing.
We're very polite up here. So one of the first things that Iowa did, it wasn't legislative, but in 2019, then Chief Justice of the Iowa Supreme Court, Mark Cady, and some administrators from the department, as well as some judges, went to a conference in Minneapolis where they heard a speaker, and the speaker talked about essentially that removing a child creates, I think she said, a mortal wound in the child. So a couple of the judges were like, I've never heard of this. And so they worked with that presenter to create 4 questions to help guide decision-making on if they ever received a call for removal. So the 4 questions were essentially, 1, can you remove the threat? If, let's say, the perpetrator is parent A, can parent A leave the home, child stay home with parent B? Child and the safe parent, using quotations, they stay in the home, but somebody comes to stay with them in the home. Parent and child leaves the home, or if the child needs to temporarily be separated from their parent, who can the child go with that they know and love? And
can we just pause here to recognize how basic those questions are and how infuriating it is that judges aren't asking those in every court proceeding where we're deciding like what is in the best interest or what is contrary to the welfare, that we had to write these down and tell a bunch of judges, like, please try this novel approach out where you ask questions about how to reduce harm. Just want to flag it as real basic.
yeah, and it was a pilot that 7 judges did. It was called like 7 judges, 4 questions, and approximately, I would say I think they got like 88 or 89 calls for removal. About half of them were granted. And then when they were granted, I think all but maybe 10 or 12% went into stranger foster care. So it clearly will help if you actually think through the problem systematically. Then on the legislative piece, in July 1 of 2022, House File 2507 went into effect in Iowa, and that was a pretty sweeping legislative change for our Chapter 232. So within it, they added that within the rules of construction, they say that the preference for a child is to stay with kin whenever possible. And then they also added in this balancing test as to where there needs to be substantial evidence that the need for removal outweighs the potential harm removal would cause the child, including any physical, emotional, social, and mental trauma. So now that is in our code multiple places, but as we'll talk about later, there's really no guidance on how that balancing test occurs or what substantial evidence looks like. And also within 2507, a preference was given that the preference is that if a child needs to be removed, the child would go with family. That previously was not in code. And I don't know if this really is good, but they codified safety plans. Yeah. So that's 2507. So yeah, I will talk more about that.
Okay, and can you just tell us what the effect of the pilot was?
Yeah, so as I said, like about 50% of the removals were granted. We tried to, well, we still encourage judges across the state, so to move away from just the 7 judges, but from across the state to ask those 4 questions when they are approached by a judge for a removal. Some do, a lot don't. So it's really unfortunate because here's something that clearly made a difference. And our second, aspirational phase was to create another 4 questions if a child was removed to get the child back home. Like, why can't the child go home today? What are the immediate safety threats that need to be addressed today? Can we make an in-home safety plan to get the child home today? But because we're still trying to get the 4 questions on the front side, we never really advanced to the 4 questions on the opposite side.
All right, let's talk about Washington.
So the state of Washington's been really, really busy, and I will credit that, honestly, to the work of the coalition that I'm one member of. So it's the Keeping Families Together Coalition, and I hope that I'll have an opportunity to talk about all the people in the coalition. But I want to first just give a shout out to Shanta who's the leader of our coalition, and everything that I'm going to say that was achieved really was achieved as a group and with her as the sort of steering the rest of us. So we've done a lot. So I'm going to go really fast, and I can talk really fast. And then if you have questions later, you can flag me because it's a lot that's about to come out of my mouth. Okay. So first, we passed House Bill 1227, which did a number of things. And the intention around 1227 originally, it's called the Keeping Families Together Act, was, is there some way that we can make a bill modeled on ICWA that would be specifically intended to preserve Black families? And that was intended, the inspiration for that came from other people in this room, from Minneapolis and the African American Family Preservation Act, and there's work that's been happening across the country around that. But for legal reasons that are boring, but I can explain to anyone who wants to hear, that was not going to be possible in Washington. But we did take what was great about ICWA, the Indian Child Welfare Act, and tried to make it available to all families to sort of lift the floor for removal, and we did that in a few ways. We changed the removal standard from a serious risk of substantial harm to an imminent threat of physical harm. So imminent means right now it's going to happen, and physical means emotional harms or speculative harms or future harms might not be allowed. We also required the state to show a causal connection between the risk of harm to the family, and the harm in the home. And we said a whole bunch of things can't form that causal connection. Again, this is ICWA. So substance use can't form that connection. Mental illness can't form that connection. Homelessness can't form that connection. Age of the child, age of the parent, in utero exposure to substances. You can't, so no shortcuts. You can't say, this baby was born positive, tox, remove. You have to say more about how the child's going to be harmed in the home and that it's an imminent physical harm. And then we also require courts to consider the harm of removal. We likewise did a bunch of other things too to create a presumption of relative care. To place out of the care of a relative, the state has to show that the relative possesses or presents an imminent physical harm or would hinder reunification. And then we did a whole bunch of other stuff too that I won't have time to go into, but then we passed a whole bunch of other bills. So one is House Bill 1747. Among the things it did is it created a guardianship rule out. So it says you can't move to adoption without considering whether a guardian is available. And that changed the standard for termination of parental rights to require the state to disprove the availability of a guardian. And I think that that's important to talk about needing to have both a front end and a back end strategy, because as long as there's a market for the children in the system, and as long as they can get out of the system and become a closed adoption, then I think these children will always enter the system. And we, uh-oh.
You guys did so much cool stuff.
Yeah, well, and then there was a bill about visitation that I won't talk about now. And then also we ended the state's use of taking child support money from parents for child support. And so the state can no longer go after parents for child support when they've taken their children. And then other things too, but I won't get into all of it.
Okay, so Washington did a lot. And, one of the things that we were talking about while we were prepping for this session was that we don't always know what the other people in our movement are doing. And it's one of the things that we want to work on being better at, because even though we're on a lot of listservs and working groups, we didn't know Washington did all this stuff till we started putting all this, and we were kind of talking about why that is. So just something I want to keep front of mind, that we have to think about ways to disseminate information to each other so that we can really learn some of the lessons from along the way. Okay, I get that a lot. I'm going to slow down. Okay, so I want to talk about what we think are the kinds of changes we can make to the law that are most likely to reduce harm, and how you think the work that's already been done on the laws that you talked about can do that.
So I think that if done correctly, the test where you essentially weigh harms of removal versus harm of remaining could do a lot. Because the way I conceptualize it is, oftentimes when the decision to remove is being made, it's being done more so with a focus of fear, in respect to, you don't want to be the worker who whose name is plastered on the news because essentially you made the wrong decision, as if we have a crystal ball. So I think that by saying, okay, what are the harms that are actually going to occur if I remove this child from their community, from their school? Do they have a close connection with their teacher? I mean, because if I go to the school and the teacher's like, I look out for Johnny, I don't know. I don't know that that kid's gonna have the same level of support in the next place they go. So it removes a little bit of, I think, kind of like the nebulous concept of harm and risk, and it actually requires also a focus on the child, as opposed to, again, what I think sometimes is a focus on the worker and fear of being wrong.
Yeah, and I think, we're seeing that play out in real time, right? I'm sure, as you all saw, a child died in Brooklyn about a week ago, and that judge's name was plastered all over because we need someone to point the finger at, right? And that fear for people in the system is real, right? I don't want it to be my name on the front page of the New York Times or the New York Post or whatever. And thinking about balancing harms, it's sort of a recognition that there's not only one kind of harm, right? We focus so much on, is there going to be physical or even emotional harm, without thinking about all this other harm that happens when a child is removed from their parent, sibling, school, community, right? Tara, what do you think?
So I think a thing you're going to hear all of us say maybe a bunch of times is that the law actually doesn't ever change people's behavior. And this was a very weird thing to come to a realization about as a lawyer, but I really do think the law exists as a justification for people's behavior, sort of a post facto justification for people's behavior. And so changing the law is not going to change people's behavior. What I think has, to the extent we have been, and that's a real bummer, right? Because it's in some ways, changing the law is an easier thing to imagine than changing the hearts and minds of all the people doing harm, and which is, the battle that I think all of us are engaged in every day, and so much helpful information already today about how to do that. So that being said, I think that the things that the law can do that can limit harm and hold the possibility for things to be different have to include an actual change of power in how the system's allocating power. And so, and I think and one of the ways you can do that, and one of the ways that we've done that, is just to make it harder for the state to make their case. You just got to show more stuff. They've got to show more work. They've got to do more work. And we're already getting some backlash about that. Like, there's just so much more paperwork. There's so many more questions we have to answer. There's so much more we have to do. But I really did imagine it when we were originally conceiving of the first bill, House Bill 1227, the Keeping Families Together Act. Like, let's make a little maze. And there's lots of twists and turns in it, but if you want to get to removal at the other end, we're going to make you walk around and around and around and around and answer lots and lots and lots of questions. So, first you've got to talk about whether the child would experience imminent physical harm. And that's going to be a narrower front door than serious threat of substantial harm. So if you make it through that front door, then you've got to show a causal connection between the parent's behavior and we're not going to let you use any shortcuts for that causal connection. And then there's going to be like another turn where you're going to have to talk about the harm of removal. And we're sort of twisting and twisting, and then you have to really go through this question of relative care, and we're going to make you let every relative testify. We're just going to make this whole hearing take forever. And just by putting a lot more, making the decision to remove a child take a lot more work, I think, first of all, there's the possibility, and the research shows that we might get to, the research is about higher quality removal decisions, but we might actually just get to fewer removals, and that was our hope and the intention of the legislation. But I think, and this panel is focused on the harm of removal, and the reason why I think the harm of removal is an important part of the bill, even though I would think of harm of removal as actually a reformist reform versus a non-reformist reform, because when you have the harm of removal, it's a balancing test. And so the state gets to talk about the harms that the parents present, and you get to talk about the parents' advocates gets to talk about the harm of removal. So it's not, it opens the door for everyone. That being said, being able to talk about the harm of removal forces everyone in the courtroom to talk about what we're doing as a system of harm, even for a little bit. And that, I think, has the possibility of changing the conversation and forcing people to talk differently about what we're doing, and in particular to force judges to think about what they're doing as a harmful act, and to at least contemplate that, sit in that for a moment, judge, that you are causing harm, think about the harm you are causing. And I think by doing that, we have the possibility of changing people's hearts and minds a little bit, which, not because the law required, not because the harm of removal will always outweigh the risk of harm to the child. If we were actually following the law, we would remove no children. The reason why I think it's an effective strategy is because it forces judges to think about it more, which might actually limit the times they make the decision to remove.
Yeah, thank you. So let's talk a little bit about strategy, right? Anyone who's done any of this work knows nothing is happening. We're not getting from A to B overnight, right? So what did it take to get from point A to point B, and what are the main strategies that you use to get there? But also, what challenges did you face in trying to get from point A to point B?
So this is, I think, interesting because the two states did it very differently. So in Iowa, personally, I was not involved in the legislative piece. It was actually spearheaded by our department. And our department, along with people that they chose, rewrote Chapter 232. And once they had a draft that they were willing to pre-file, that's when they shared it with the judicial branch. And it was tell us your thoughts on it. So it was hey, you have a week and a half to do a complete analysis on 60 pages of proposed legislation. I was cool, yeah. And it was over the holidays, so it was cool. I wasn't involved, but I will tell you that there wasn't pushback at the legislature. Iowa right now, the branches are united. So when the department brought this legislation to the legislative branch, there was no pushback. And in campaigning for these changes, they really centered families first. And they kept saying, these changes are gonna help effectuate families first. These changes are being driven by families first. And because that had just been signed and Chief Justice Cady, when it was passed, he formed a task force, I love a task force, to essentially figure out how the judicial branch was going to get ready for like the changes in the law and how we could do it correctly. But that was like a multidisciplinary task force. But so it was this wave of everything is families first. And as we'll talk about later, there's some non-families first things that were in that bill. But so for me, the challenge is much more so implementation. So now we have these words on paper and we don't want them to mean nothing. Like reasonable efforts have kind of come to mean nothing. They are findings that need to be on an order, so then that way everyone can say that they tried and Title IV funds can continue to flow. So our big thing was, how do we make these words actually mean something? So at the CIP, we were kind of like, so I have like two other like colleagues. One is our executive director, the other is a deputy director. And we very much were like, okay, so we didn't ask for these words. And because typically when we try and push for a change, it's more so like, can the department support that? Their workforce, it's more work. So we were like, this isn't us. These are the words that the department put down. So I didn't create work for you. The department created work for you. So now you made these words, put up or shut up. So it was us trying to figure out like, what are the things that we can say, hey, judge, you should consider X, Y, and Z when you're trying to make this substantial evidence determination. And Washington courts has this really cool like map of like harm of removal. And so we are working with judges to say like, hey, how do we take into account like community harm? How do we take into account physical harm? How do we take into account the fact that this kid grew up in the same neighborhood, knows all their neighbors, that's their auntie down the street, and now we're gonna put them in a completely different place and just say like, you're resilient, like let your resiliency like help you through this. So it's like there are all these things now where it's like they invited us into this domain essentially, and it's kind of a catch-22 because it invites like the hyper-intellectualization of family and like complex relationships, but now it's also like, now there's more work to do, but I think that these are determinations and things that are often not taken into account because we are, and I say this as like somebody who did like removals and things like that, like you don't want to be that worker with their name in the news. And it requires you to slow down and say, okay, this kid is 14. This kid has friends in the community. Yeah, parent has issues of substance use disorder, but child understands that. They love their parent, they trust their parent, they feel safe with their parent. Is this like I don't even know what the ideal circumstance for anyone is. Like, I don't even know if I had ideal circumstances. So it's like, so I can remove this child, put him in a shelter, because I'm factoring older youth likely going to a shelter, don't know who's gonna be in that shelter. I know abuse occurs in shelters. So I can make the decision to say, you know what? Me removing for essentially what would be substance use and poverty, that is not as great as the harm that I'm going to do to this kid right here, right now. And so we are working with judges to come up with like questions and like things that they can like explore further to get to this harm of removal question.
And Tara, how did the approach in Washington differ from the approach in Iowa?
Yeah, so I would say the most important thing that happened was that the coalition came together. And I would say this is the kind of thing that everybody can do because we have we have everybody as a member of we have a lot of different people in our coalition. But we had the right size group of people that we were able to be nimble and effective and be on the same page. And then we had a lot of different interests represented in the coalition itself. So I already mentioned Shanta Selvanov, who's our leader, and then Carla Arnold, who's actually having some health challenges. So if anyone wants to send a little positive shout out in their heart to Carla right now, let's all send her a little shout out for her health, who runs an agency that does family preservation services, among other things. We had young people's lawyers from LCYC, Annie Chung. We had Mockingbird Society, young people them organizing themselves. We had a foster and an adoptive parent, Katie Byron, on our coalition, and Jill May, who's from the Washington Association of Children and Families. And so every member of the coalition brought something to the table. And then we met all the time, regularly, and we had regularly standing meetings and came up with what we wanted to do. And just absolutely inspired by some of the comments this morning, but this is actually a few years ago, we decided we really wanted to focus on those most impacted by the system. And so it was really trying to figure out how to reduce the removal of Black and Indigenous children was the focus of how we decided to go about thinking about the law. And then trying to figure out how we could package it in something that would be embarrassing for Democrats to vote against. In 2020 is really that's the challenge. And so you want to get your thing together, and then you want it to be the kind of thing that is going to be really hard to say no to once you see it. And so our strategy was leaning into ICWA in the Indian Child Welfare Act. We have very many strong and powerful tribes in the state of Washington. Obviously, ICWA doesn't apply on tribal land, but they're interested in making sure that ICWA was being followed in state courts. And there's a lot of conversation around how ICWA was facing challenges, and it was facing challenges in the Supreme Court. And so our legislature really was pro-ICWA. So when we were talking about our legislation, we really packaged it as learning the lessons of ICWA and applying those lessons more broadly and more widely to other children in the state, and then really highlighting how Black children haven't had the benefit of anything like ICWA, and how changing the law to be more like ICWA could benefit Black children by preventing those removals.
Okay, so coalition, super important, making sure all of our constituents are represented, and really thinking about who's leading the coalition, right? And I'm also hearing threads of what the lawyers in the room would call what's your case theory, right? What are you trying to sell to the legislature that makes them buy in, right? Embarrassment is also a great tool if you can make it work. So I wanted to talk about what has happened since the legislation passed, right? What have been the results? Did it accomplish the goals? But also, we sometimes get wrapped up in the process. We're we want to get this thing passed. We want to get this thing passed. And we can lose sight of the goals, and we can also sometimes miss things. So was there anything that surprised you after the fact, with the benefit of hindsight?
What has changed? Nothing, unfortunately. And I guess I can say that it's been a year, and maybe that's why we're not seeing the vast difference. But I'm going to be honest. Yeah, there is nothing that's really changed. In hindsight, I think I mentioned earlier that. So at the CIP, I am the only staff attorney. So the way the CIP is set up is that there are 3 people in the judicial branch in Des Moines. All 3 of us are social workers. I'm the only attorney. So it was, hey, here's this major rewrite of legislation. Tell us your thoughts. You have a very, very short period of time. And I will say I missed stuff because it was more so it was a lot. And as much as I want to say that I'm super awesome and brilliant, I'm not. And it was... You are.
You are, but there's a limit to each of our capacity and capability, right? And some tasks are just unreasonable.
Yeah. I'm beating myself up because there are things now that I'm wow, I can't believe I didn't catch that. So in Iowa, parent visitation used to be a standalone right. So it was 232, 112 or something. They repealed that. And then they moved visitation under reasonable efforts. And the parent visitation statute was used a lot for incarcerated parents. And so now it's like, what is that? What does that mean? Because I don't want to say that this is what the courts will do, but it's probably easier to say that it's not a reasonable effort for incarcerated parents to have visits as opposed to you exercising a standalone right. Now within that reasonable efforts determination, it's like, is it reasonable for you to take a child to jail or something like that, as opposed to it being a standalone right and it being like, you're gonna do it. So there were just things that like, and granted, even if I caught them, there's a strong possibility they wouldn't have changed anything. But now it's very much like I wish I had more time. And I will also say, like, there were some things, because there was like a companion House file at the same time, and it had some unintended consequences. So those were mainly regarding adoption, because former foster youth were like, hey, my sibling would be adopted, and I would have no idea. And so they changed the statute so then that way siblings could get notification of their sibling's adoption. And within that statute, they said that, like, they get all the attachments. An attachment includes like the home study for like the adoptive parent. So there was major blowback because it's like, so I have to serve an infant and I have to give that infant all the attachments, including those of like the adoption home study. And it also kind of created this fictive right. So I as a sibling can show up and be like, I don't want my sibling to get adopted, or maybe the court says, no, but you guys should maintain a relationship and visitation. There's no enforcement for that. So now I have great concern that now we're going to have youth and former youth throwing up and thinking that like this somehow, because now we have to find this court finding that continued visitation is like in the child's best interest, and they think that's going to do something. And the minute that adoptive parent walks out, they can say no, and now we've created more harm to people who have already been harmed. And it's just that now, I mean, looking back, there's just a lot. There's just a lot.
Well, I think that really highlights the benefit of coalition, right? Because one person standing by themselves with their law degree and their social work degree is going to miss stuff. I can't think of how many times I've looked at, you know, a piece of writing or a bill, and I miss tons of stuff, but it's one of the reasons I always send it to a whole bunch of other people too, because I might be looking at it through one lens and somebody else is looking at it a different way. And that is the reason that we do this work collectively, right? Because we all have different perspectives and different strengths. And if you don't have the benefit of that and you're standing on an island by yourself as the only lawyer who's reviewing this legislation, I mean, I don't know how you wouldn't miss stuff. So Tara, what were the results on your side, and any surprises? Do we meet our goals?
Yeah, we won.
It's over. You can all go home.
We won. No,
Washington State fixed it.
Yeah, we fixed it. No, we didn't. I mean, didn't fix it. The sort of top line response is that I think you would hear from people that removals are down pretty significantly, and that is great. And also probably not solely the result of this one piece of legislation, but the result of a whole bunch of other factors as well. So not trying to say that this is the law that did it. And, you know, but I think also racial disproportionality might be up, which is a thing that happens often when the system gets to focus more of its attention on fewer people. It turns out the system continues to focus on, in Washington, Black and Indigenous children. So that is, you know, fewer children overall and fewer children of color are being removed, but maybe a greater percentage of the children who are being removed are children of color than before, which is depressing. And so I think that you know, well, I don't want to speak to all the things that have changed, but what surprised me, I will just say really quickly on the child support piece. I just want to say one quick story about what surprised me, is how like the state was trying to help us not collect child support in Washington. We went to the state of Washington and we're like, look at this study that shows that you spend, I think it's like $1.30 for every 25 cents you collect in child support. Meaning you're spending money, you're trying to squeeze blood from a stone. Like, you should stop doing that. And then it also reduces it increases the amount of time that it takes for children to be returned home, like, stop doing that. And they're like, yeah, for sure, we definitely want to stop doing that. Let's stop doing that. How can we stop doing that? And we're like, well, here's a few ways. And we had to think through a few ways. We had to talk to the 4E overlords, because we can't do anything without the permission of the 4E overlords. And we had the 4E overlords to buy in. And then it was the defense attorneys, not my office, who were like, yeah, but that's how we establish paternity, is through a child support referral. And we don't know how we're going to establish paternity without a child support referral, and we don't want to do that work. And the real, the reluctance to, so just some of that reluctance surprised me. Sometimes the people you think are going to be on your side aren't always on your side.
I'm a little stuck on that. I'm going to try to move on. We want to leave time for questions, but before we do, we want to talk about the lessons that you learned from, trying to either from trying to pass legislation or from trying to implement the legislation, trying to actually make it work. But also what you think generally about using legislation as a way to effectuate the kind of change that we're talking about.
So I guess in the grand scheme of things, be like Washington and build coalition. So then that way, hopefully it's more thoughtful, and it sounds way more expansive. So yeah, you guys did cool stuff. So in respect to law is not transformative. I will give the person, whoever thought of the concept of reasonable effort, some benefit of the doubt and think that maybe they were trying to create something that would actually help. I'm being very generous with that. But so you would think that these words and this thing that really has kind of taken a life of its own in child welfare would mean something. But a demonstration of how law was not transformative or is not, in Iowa, there is case law that says that reasonable efforts aren't a substantive requirement to termination. So the concept of reasonable efforts is taken into account to the totality of all the things the department did. So it's not this substantive thing that I would hope, fingers crossed, that the drafter thought it was going to be. Within Iowa law, it talks about how, or case law, about how we can't wait for a parent, because kids need permanency, and patience for the parent was essentially put in the code. How do you put in the code patience for a parent? It completely removes humanity from people, and I don't know how law, especially given the history of law, can create humanity when it has been used so often to strip people of it. So that is a big thing. And then another thing, be leery of grand statements. So House File 2507, it was all done for families first. Within that bill, they also removed the word frequent from sibling visitation, because frequent, how do you define frequent? So now a child just has the right to visitation with their siblings. They removed frequent. So in federal law, it says frequent. Iowa law, it does not say frequent anymore. It created, so before the change, custody of a child during a child in need of dependency case could be given to a relative. They got rid of that. And by getting rid of that, they essentially got rid of one of the permissive exceptions to termination. So we used to have 3 reasons why you didn't have to terminate. It's essentially down to 2, unless the child goes with their other parent. So by that change in law, they made it more punitive. But it was done for families first and keeping families together, and it's all about family. And it is just mind-blowing. So laws don't change beliefs. Laws don't make people who work in the system see families as families worthy of dignity, protection, and all the things that they would want for their families. It doesn't change hearts and minds. The only thing I can say is maybe it can help. I don't know how to say it, but like, for example, maybe it can. It sounds terrible saying it, but like, law is like, the way law works, it makes it sound like it's void of humanity and people, and it's just like these words that are neutral and there's no bias or anything in them. So like when they created this harm test, like it introduces more humanity, because before the law was a little bit silent on things like community and the child's mental health. And so that was a way of kind of injecting it into law. Now, again, it's up to us to make those words mean something, but that is probably the best way I can say it's helpful.
Tara, your lessons, words of wisdom?
Oh, yeah. So the words of wisdom are so I want to take back one thing that I said before, which is about we packaged our bill in a way to embarrass Democrats into voting for it. That was true, but I actually think the reason why we got the legislation passed is because of the strength of our coalition, and particularly the strength of our leader, Shanta, who has the ability to make legislators care about this topic and to make legislators want to do and behave differently. And when you have someone like that in your community, just getting behind them and figuring out how to empower them and is, I think probably the best strategy. And that has certainly, I think, worked in Washington. But I do think it's a sort of, I've been watching our coalition show up in meetings with legislators now for a few years. And I think people sense that we care about each other, that we actually really we do love each other, and that, we're inviting those legislators into our circle of like actual affection that we have for one another. And I think that feels good for people. It feels good for people to want to be invited into a space where they feel welcome and they feel like the people want to be connected with them and connected with their humanity. And I think that's kind of the brilliance of this work, and what is so special to me about this work and so special to me about all of you, and what makes me so grateful to be here, is when you've decided to show up for the love that parents have for their kids and to fight against state violence on behalf of the love that families have for one another, then that's like the best kind of person to be around, is a person who wants to show up for love and defend love for families. And so when you get those people in coalition, you can have, I think, really beautiful relationships, and then maybe make some changes, and maybe those changes can ripple out a little bit further, and maybe a little bit further, maybe a little bit further, and we'll see.
All right. So we have no magic answer. I'm sorry if you thought that's what this was going to do. But, I think the one answer we have is that we need each other, right? We can't do this work alone, and that we all have something to add and something to offer, and we also have to know when to step back, right? Especially for those of us, like myself, academics, lawyers, social workers. Sometimes it's time for us to step out of the way, right? And support where needed. I want to give time for questions, so if anybody wants to ask a question live, there's a mic. But I have some questions right here, so I'll start with this one. What might be the policy implications for the privatization of the system that is underway in Texas in places like Texas, for example?
Well, I don't know what's happening in Texas, and it would be wrong for me to speak to it. I do know that in New York City, there's a number of private agencies, and I've worked, and I know about how those private agencies work with oversight of the state. And the system is the system, whether it's private, whether it's public. It's a system that's intended to perpetuate harm and does perpetuate harm. It's intended to perpetuate racial terror, and it does perpetuate racial terror. And I think, but the less accountability the state has to take for it, the less we have, so the less you know who you're talking to. And I will say that's one of my lessons of trying to figure out who the 4E overlords were for Washington State. You couldn't even find their names online. Having less transparency in who the system is that's perpetuating harm, I think, makes it harder to fight, and I worry that privatization has that effect. But truthfully, I don't know enough about Texas to say for sure.
So I will just say that there are some industries or areas that just should never be privatized. Human services, healthcare, I think that those should not, because so long as they're privatized, there's going to be a focus on capital and making sure that that company yields a profit. And there should never be a consideration on if anyone's going to yield a profit when it comes to maintaining families or somebody getting the healthcare that they need or somebody getting food. I'm not okay with that.
Yeah, I mean, I think you can look at the privatization of prisons for lessons learned, right? If we are going to build a system where we have beds to fill, we will find ways to fill those beds, right? If we have cells to fill, we will find ways to fill them. And if we have spots in foster care and we have workers at all levels that are dependent on kids being in the system for their salaries and for the agency to continue, we will remove kids to fill those spaces. And to the point about transparency, it is really hard to get information in that way. You know, if it's the government, you can file freedom of information requests. You can get documents in a different way that you can when it's a private entity. So I also don't know a whole lot about what's going on in Texas, but I would say as a general principle, privatization is not a great idea.
If there's a corner to cut, they're going to cut it.
Yeah.
And there's only one population that's going to be harmed from cutting corners, and it's not going to be the corporation.
Anyone in the room have a question? Yeah, Ayami. Yes.
Hi, thank you so much for this talk. It was wonderful. You talked a little bit about the limits of legislative advocacy. The law doesn't change people's behavior towards that. Just now, you guys mentioned this is an industry and how their livelihoods, this whole industry is dependent on this terrible thing of separating families. And I think a lot of us in the room do a lot of legislative advocacy. And I understand it's one piece of the puzzle. I know we said there's not a magic formula, but I'm wondering what are some strategies that you guys have, put together with legislative advocacy? I don't know if you could talk a little bit more about the limits, but also maybe if there are other strategies, other tactics you've used towards, what we might call shrinking the system towards abolition. How do we kind of build together a package of strategies, perhaps? Thanks.
So in my role, I don't really do much legislative advocacy. I have to maintain neutrality. There is a legislative liaison for the judicial branch who can do that kind of stuff. So the way that I try to do what I can is I try and focus on the judges. So I don't know who all knows what a CIP is, but a court improvement project, every state has one. It's a monster of Title IV, and the whole point of a CIP is that you're supposed to help the legal and judicial professions respond and understand child welfare cases. So we do a lot of judicial branch education, and we do a lot of education for attorneys. So I try and suggest people to come in and talk about certain things. I got to go to the Bergstrom fellowship to sit in on their fellowship because I didn't know about it, and we want to try and do something like that in Iowa. And I heard one of the speakers, and I'm like, hey, people need to know about the history of child welfare. So then I was able to get that person to come to Iowa. She's going to come to Iowa. He's going to come to Iowa. So my thing is if I don't want to say shove it down their throat, but if I can create a space where people have to hear it and they're not just in an echo chamber where they hear and are encouraged by their beliefs in this cyclic confirmation bias, if I can interrupt that, I try and do that however I can.
Tara?
So I love your t-shirt, and I think that means that you're already closest to the person who has the best answer to that question, which is the person sitting next to you, Joyce McMillan. And I think that it's really about, for me, hearing what the people who are most expert in the system tell us we need to fix and tell us how we need to fix it, and then fixing it in that way. And I think what's so brilliant about so many of the strategies that I've seen coming out of New York and coming out of Joyce's work, but also honestly coming out of Washington and work that's happened in Washington too, is ending mandated reporting is only a step. You could make it so that a person doesn't have to report. as long as there is a place to report to, people are going to still report. So unless there is a campaign of the kinds of campaigns that are happening around the country and happening certainly in the work of JMAC for Families, where people understand that actually calling is harmful, like actually changing people's belief system together with changing the law, then you might actually get something to be better from my perspective. But just changing the law by itself, if you abolish mandated reporting today in Washington state, I don't think the numbers of intakes would go down a little even. I think they'd be the same. I think it's really about marrying those two ideas.
I also think there's part of the legislative strategy is education, right? There's a couple, there's one way is to be sort of defensive when people introduce bills, show up to tell the legislature why it's harmful, but also how are you working in coalition to bring your own bills so we're not always on the defense, and we are trying to think of what the law should look like and taking an active role in that. Also, there's been many bills that we've worked on that had no chance. They were never going to happen. We knew that. But just getting in the room and talking to people about why we thought the bill was necessary, you could see the looks on their faces. They were like, we had no idea, right? So a little bit of education goes a long way, especially with legislators who really are thinking about a million things. And this is like one little issue out of the million that they're responsible for. On the bill that we passed in Maryland to clarify that marijuana use standing on its own is not neglect, I remember that one of the delegates raised his hand and said, well, how would someone even know if a parent was smoking marijuana? Would they have to get arrested? And I was like, oh man, sir, let us back up a lot, you know? And I got to explain the entire system, right? How, from a call all to not knowing their people's rights when they knock on the door, right? And really make a lot of points with that one question. I think just being in those spaces and taking up space when other people are also testifying and often saying a lot of nonsense, and being able to say, like, there is another side to this. There are a lot of smart people who are thinking about this too. And I think sometimes our, I don't call them adversaries, but people on the other sides of these issues act like they're the only ones who know anything, right? And it's important for us to show up and say, there's a lot of information on the other side too. And if you're open to it, we're willing to share it with you, so that people have something to consider.
Anna, is that you've not legalized marijuana yet.
It's legal. It's legal. It's legal.
Everyone has not legalized marijuana to me.
It is legal.
Like,
we just did. We never connected to parenting. It's like you all want to smoke it with your friends, but you don't want parents who are in the system to be able to smoke it too.
Wait,
right?
That's just, yeah.
Everyone was quick to say, I don't smoke marijuana, but
I do smoke marijuana.
I feel like we should just drop the mic. I don't know. We're done here. We're done here. Yeah. Keisha. Take the mic. Should we just end on that note?
I just have a quick question. So I love the discussions and stuff that we're having, and thank you all for coming and sharing. Question that I have is, did you, in the work that you did in passing this legislation, bring people from the outside who are not a part of the system into the conversation? And if so, can you give us any tips on how we can bring people from the outside into this conversation so that we're not continuing just to preach to the choir?
So I will say that our coalition originally, the person who formed the coalition was Lori Lippold, who I have not mentioned yet, who was the person who had the key to all the doors. She had relationships with all of the state legislatures. She was a person of enormous power in our state. And she decided to use, in sort of the summer of 2020, she decided to change the way she was operating and invite new people in. And at the very beginning, we were all brand new. We had just been invited by Lori into rooms that we never thought we were going to get, or I never thought that I was going to get to be in before. And I think we're now at the stage in our coalition building where we can think about what what an even broader group of people would look like. But back then, it was sort of like, how many Zoom tiles do we have? And how can we get to know one another well enough to get some things done right away? But it was always, and the lived experience of the system was always the driving force of all of the aspects of the legislation. So people with lived experience were parents who had their children removed, and also children who had themselves been in the system were the sort of were the ultimate deciders about what the legislation would look like.
Okay, well, we are at time. We're all happy to continue to, we all want to continue this conversation, not just in this room, but going forward, and so that we can keep learning from each other and learning what mistakes we've made and how not to duplicate them in other states. I have a whole lot of thoughts about the legislation that was passed in different states and thinking about how we can not make the same mistakes over and over after doing all this work to pass legislation that's not going to work, right? Because we don't have enough in there to hold people accountable, et cetera. So I want to thank my colleagues Tara and Carrington for joining us, and for all of you for joining us. And thank you so much.